5 seconds to go. Start. They managed to surround the appellant, who was closer to them. Stop. Apprehending an imminent and real threat to his life, the appellant had fired from his rifle at the intruders in self-defense, and the deceased, who was a part of the group, sustained bullet injuries and had fallen on the ground. Stop. The trajectory of the bullets indicates that the firing took place from a higher position vis-a-vis the deceased. Stop. But that does not necessarily mean that the appellant had summoned the deceased and made him crouch on the ground before shooting at him, as assumed by the High Court. Stop. The uneven terrain of the rubber plantation with slopes and undulating surface would offer a plausible alternate explanation for the trajectory of the bullets fired by the appellant at the deceased. Stop. If the former was positioned at an elevated spot, then it was inevitable that the bullets would have hit the chest of the deceased, who was down below the slope, and made a path downwards in the body. Stop. Thus, the preponderance of probabilities would swing in favor of the plea of self-defense taken by the appellant. Stop. Para. On a broad conspectus of the events as they had unfolded, we are of the opinion that the right of private self-defense would be available to the appellant, keeping in mind preponderance of probabilities that leans in favor of the appellant. Stop. In a fact situation where he was suddenly confronted by a group of intruders, who had come menacingly close to him, were armed with weapons and ready to launch an assault on him, he was left with no other option but to save his life by firing at them from his rifle, and in the process 2 of the shots had pierced through the deceased, causing his death. Stop. We are therefore of the opinion that the appellant ought not to have been convicted for having committed the murder of the deceased. Stop. Rather, the offence made out is of culpable homicide not amounting to murder under exception 2 to section 300 IPC, thereby attracting the provisions of section 304 IPC. Stop. In view of the aforesaid discussion, the appeal is partly allowed and the impugned judgment is modified to the extent that the appellant is held guilty for the offence of culpable homicide, not amounting to murder as contemplated under exception 2 to section 300 IPC. Stop. Records reveal that by the time the appellant was granted bail by this court on 4th July, 2016, he had already suffered incarceration for a period of over 11 years, which given the peculiar facts and circumstances of the present case, is considered sufficient punishment for the offence. Stop. The appellant is accordingly set free for the period already undergone and the bail bonds stand discharged. Stop. Para. The appeal is disposed of on the above terms. Stop.